That is in paragraph 1 of my sworn appeal. Number 2, the fact that Ruben E. Padin, the PTA President, is illegally occupying the presidency in the PTA organization at the start of the controversy, he must have been barred. He must not prosper and must not be considered triumphant in an honest mistaken judgment for non-adherence to the DepEd order, hereby putting teacher respondent into ridiculous situation when forcefully removed on November 2014. It was removed on November 2014. That the decision number 3, that the decision rendered by the regional office is not compliant to equal protection of laws and administrative justice sought, but deemed misleading the fact that grave misconduct as alleged was not addressed in the stipulation of judgment other than conduct prejudicial to the best interest of the service, which does not sustain their allegation for almost 3 years have passed of waiting, even if it can be easily identified at the early stage of the processes and proceedings conducted in any investigation at the division level of Malaybalay City. That the security of tenure that a regular teacher is entitled to is hereby raised on question as embodied in the Magna Carta for Public School Teacher, and the inherent right therein was violated when respondent was forcefully unloaded and removed from his teaching load as published in a school bulletin board. Copy here to attach, marked as Annex 2 on November 17, 2024, and was reinstated on December 23, 2015, including the imposed suspension from the school's division superintendent Edelberto L. of Plenaria CISO 6 o CISO 5, dated June 22, 2015, on misconduct and conduct prejudicial to the best interest of the service. Here to attach, mark as Annex 3, a copy of the picture of published information of termination on a school bulletin board, and suspension order marked as Annex 4 respectively. Number 5, that Ruben E. Padin, the PTA President, as complainant, is having a kind of immunity for any possible charges against them, supposedly at the Regional Trial Court for willful violation of DepEd order committed as stipulated in the findings of Division PTA or Affairs Office, revealed in a resolution dated February 21, 2014. Here to attach as Annex 5, Ruben E. Padin is treated as untouchable for not being held answerable under the jurisdiction and authority of the Division PTA Affairs Committee. So this was the first page. This is the first page of my original appeal copy. The other copy was in the other original was in the possession of the Civil Service Commission So let's proceed to page number 2 as I read and for you to comprehend whether or not my appeal is worthy to be heard. So in page 2 of 3, page 2 of 3, paragraph 6, that upon reinstatement, because I was reinstated to the service, upon reinstatement to the service after the said suspension was completely satisfied and duly served, the respondent is presumed to have been exonerated. Section 65, paragraph D, in case the penalty imposed is suspension, he shall immediately be reinstated to the former post without loss of seniority rights with permanent hindi maklaro. With payment of back salaries. With payment of back salaries, since grave misconduct and conduct prejudicial to the best interest of the service is a major offense, and as such, first offense is with penalty of dismissal from the service. So there's no need for to be reinstated, but I was reinstated. The same with dishonesty through falsification of document as the second case, and no reinstatement could have been done if probable conviction is predictable. After the lapse of 3 years, more or less, the decision rendered is only conduct prejudicial, but takes a lot of time to arrive at the findings, when in fact, at the early stage of proceedings, the same is cognizable and predictable as to credibility and veracity by the task force investigator assigned. Paragraph 7, that the failure of respondents to present cogent reason accordingly for the disciplining authority to deviate from the findings of the investigation committee is based also on their failure to provide copy of their findings to respondent. Thereby, the opportunity to do so was also denied. That such failure concurs with the findings for the respondent to have deceived and defrauded the government in connection to DTR or Form 48, even without alteration or forged signature of school head concerned. And the same is still in the position, in my position today, cannot in any manner be considered as deceitful and fraudulent act against the government, as stated. Even in the absence of DTR or Form 48, still respondent received his salary is only at the discretion of the school head, and the same has no bearing to the claimed service credits of the respondents to offset his personal absences. Paragraph 8. Paragraph 8. That the Commission may take cognizance of the appeal Number 8. That the Commission may take cognizance of the appeal pending confirmation of its execution by the Secretary of Education, and to perfect an appeal, the appellant must submit 3 copies of the following documents. A. Appeal Memorandum. Appeal Memorandum containing the grounds relied upon for the appeals. Letter B. Copies of documents and evidences. Letter C. Copy furnished the disciplining authority. And D. Proof of service of copy of the appeal to the disciplining authority. So that is paragraph number 8. Paragraph number 9. First number 9. Paragraph number 9. Okay, okay, lamok. Paragraph number 9. Ay naman eh. Paragraph number 9. That this appeal on the decision rendered by the disciplining authority to deduct from the respondent's retirement benefits an amount equal to 6 months' salary upon retirement is tantamount to oppression done when respondents was forcefully removed from the service on November 17, 2014 to June 21, 2017 prior to the issuance of suspension order, hereby forcefully raised on appeal for the administrative justice to prevail. That is paragraph number 9. Paragraph number 10. That the respondent believes to avail just and fair judgment in consideration of all circumstances, circumstantial and substantial evidence relevant therein for educators to see that administrative justice is accorded properly to anyone in the or educational settings regardless of influence and economic status. After thorough review on meritorious grounds relied upon, and through this appeal without any personal biases. Number 11. That the stipulated suspension for 6 months and the corresponding amount shall be deducted from the retirement benefits of the respondent is a kind of oppression, unjust, and very unreasonable. The fact that Rosalio P. Aranco, my immediate school head, willfully and forcefully unloaded the respondent teacher of his subject taught and removed from the service as published in the school bulletin board from November 2014 to June 2015. 15. Ano to? Okay. Kapoy.